Bonjour tout le monde.
Good day, everyone. Thank you for being here at this meeting of the House of Commons Standing Committee on Public Safety and National Security. It is meeting number 28 of our committee. Pursuant to Standing Order 1082 of the House of Commons, our committee is meeting as part of its study on Canada's ability to remove foreign nationals with criminal records. I would now like to warmly welcome our witness, who is with us from New Zealand. So we have many reasons to be very grateful to him. This witness is Mr. Steve Watson. He is Director General, Immigration Compliance and Investigations from the New Zealand Ministry of Business, Innovation and Employment. I believe that the sound tests have already been completed and successful, which leads me, Mr. Watson, to give you the floor for 5 minutes for your opening remarks. Thank you.
Thank you, Missy. Bonjour, good afternoon, or good morning as it is here, and kia ora koutou, which means warm greetings in the language of New Zealand's Indigenous people. Thank you for the lovely introduction. As said, my name is Steve Watson, and I lead the part of New Zealand's immigration system that deals with removals, criminal prosecutions for criminal offending against New Zealand's immigration law, including migrant exploitation, human trafficking, and people smuggling as well. But today, what I want to talk to you about is just one aspect of my role, which you've asked for information on, which is deportations and removals. Specifically today, I want to provide you with an insight into how New Zealand manages foreign national offenders who are liable for removal. New Zealand's deportation and turnaround legislation and processes that apply to the removal of foreign national offenders are unique to our country. So they sometimes won't be aligned or it's not possible to do a linear comparison with Canada's processes, but hopefully I can give you some assistance. We have a number of information sharing processes with other government agencies that I'll outline further in the presentation that you may or may not have in your own jurisdiction. We have sharing agreements with agencies such as the New Zealand Police, our Corrections or Prison Service, and our Ministry of Justice. I'm going to keep today's presentation reasonably high level, and I won't reference specific legislation or the details of those agreements, but I make the offer to you to talk further about this or provide us any further information that you might require subsequent to this hearing. So the Immigration Compliance Team is responsible for a range of immigration enforcement work. So that includes managing returns cases, investigating visa breaches by migrants, employers and educational institutions who look after foreign students. We have a low-level compliance function that gives infringement notices or minor prosecutions to employers who breach the Immigration Act. And we monitor migrants in the community who are currently on active criminal charges or on reporting conditions. And we do a lot of joint work with our other agencies in terms of the wider harm to New Zealand's communities. So New Zealand's immigration system, like many, is founded on the expectation that migrants must meet entry requirements, and when they're here, they must comply with their visa conditions, are of good character, and do not commit criminal offences whilst here in our country. This includes a clear expectation that people leave New Zealand when they no longer hold a lawful basis to remain, so they must leave before the expiration of their visa. New Zealand prioritises the removal of foreign national offenders who are liable for deportation and also those migrants who present a high risk to our communities. Criminal offending is our number one priority. A little bit about the term removals. Removals describes all processes for requiring foreign nationals who have no right to remain in New Zealand to leave. There are three main streams of deportation. So for residents who have committed serious offences, we can cancel their residence permission. Temporary visa holders, such as students or visitors or work visas who commit criminal offences will be made liable for deportation. And then there are persons who have overstayed or remained in New Zealand past the expiry of their visa. And all of these attract appeal rights right through to a judicial review at our Supreme Court. Not everyone avails themselves of those appeal rights, but we do obviously have to respect that. Most of our deportations are around criminal liability are based on bad character. We also have a role in the compliance team of turning around people at the border who've deemed it inadmissible because they have criminal convictions overseas, and if we find out about that upon arrival, we will detain them and turn them around. We do have a graduated compliance model, so our responses are proportionate to the harm and risk-based and tailored to the individual's circumstances. While some non-compliance is resolved through education, facilitation, or voluntary departure, cases involving criminality or bad character or refusal to engage are treated by higher priority. And like many countries around the world, there is high public interest in New Zealand in migrant offending. So in terms of custody and detention, most of our low priority cases are resolved through community-based limits on movement, such as reporting conditions. We have recently passed legislation where we can do electronic monitoring for some criminal offenders in the community. But our serious cases, we make every effort to deport directly from prison or immediately following the court hearing. So in terms of detention, we have a limited 4-hour power of detention immediately after arrest of a foreign national who's liable for deportation. And then we take them to a police station where a decision is made. We have 96 hours to decide whether to detain them on a warrant of commitment, which is sought through the court, or whether to release them on conditions. And the 96 hours also allows us time to book travel where appropriate to remove people from the country. So in terms of information sharing, all foreign nationals who are under investigation by the police or charged with a criminal offence or convicted by the court are of interest to Immigration New Zealand. For the reasons I've outlined, we expect visitors to our country to obey the law the same as we do for our own people. And the police and ourselves have a data matching problem, a data matching system, which has some problems, mostly around identity. So we do have to validate some identity because it is just a straight name-to-name match. So we do have to do a little bit of work to validate that. But the police will tell us of all foreign nationals who they're aware of who are charged with criminal offences or have been sentenced to imprisonment. It captures most foreign national offenders who are committing serious offences. And where a person is on a community-based sentence or is not sentenced to a term of imprisonment, we work very closely with our corrections and probation service so that we can deport them at the earliest opportunity, which means that as soon as they have served the minimum part of their sentence in New Zealand, we would put them on a plane and return them home. So I'll just quickly run through our priorities. Our priority 1 is for prison releases, our criminal offenders and national security matters. So that there are four subcategories under priority 1. That is those who threaten national security, and that's a joint piece of work that we do with our security agencies. And people who have been granted residence but who have committed a serious enough offence to make them liable for deportation, prison releases, home detention sentences, and people who've committed visa fraud. Our second priority is a tier down from that, and it is around people whose offending shows that they have adverse character issues. So that may be minor assaults, street violence, drunken charge. That's just a small snapshot of the offending that where people are not sentenced to imprisonment, but their character it demonstrates poor character sufficient that we would want to revoke their visas and deport them from New Zealand. So that concludes my opening introduction, and I am now really happy to take questions from the members.
That is wonderful, Mr. Watson. Thank you for this excellent introduction, which then allows us to turn to MP Caputo, MP Lloyd, sorry, for 6 minutes.
Well, thank you, Mr. Chair, and thank you, Mr. Watson, for being our witness today, all the way from New Zealand. Some of my questions here, I'm going to start off with, this is a quick one, does New Zealand maintain a public web page where they provide information about wanted criminals who are wanted for deportation?
No, we don't. No, we don't have a no, we don't have that facility at all. In some serious cases, we may use the media or put discrete articles on our website asking for specific cohorts of people, but we do not name individuals.
Is there a reason for that?
I'm not sure of the reason. There are privacy legislation that protects the identity of some migrants, because but those who have committed a criminal offence, we may name them. It normally takes the form of this person has been convicted in the court and will be subject for deportation, but we don't specifically name people who we're actively looking for, generally because it's a small country and that may drive them further underground.
I see. Something we've heard during this study is that foreign governments can be very uncooperative in some cases when we're trying to return their citizens, and they'll use things like not providing travel documents. Is this an experience that New Zealand has, and have you been able to find a good workaround?
Yes, it is an experience that we have had, and it changes depending on the geopolitical situation, of course. I really want to be at pains to say that we have no issues with our Five Eyes friends. But in terms, probably our most difficult country at the moment is we're having problems with the Vietnamese, just in terms of getting travel documents. But mostly we have good relationships with our consular partners in New Zealand, and we, whilst there can be sometimes delays, generally we will ultimately get a travel document. But it generally depends on the relationships between the country. Sometimes there can be diplomatic tension, which plays out in difficulty in travel documents. But we're a small country and we have got really good connections. The other thing that we leverage off is our Five Eyes partners.
Aussi, nous communiquons avec des partenaires qui ont parfois des connexions, des liens qui peuvent nous aider.
No. In 2024, there was a notable case in Canada, I'm not sure if you're aware, where there was an ISIS-inspired attack that was foiled against Toronto's Jewish community. One of the alleged terrorists was able to evade immigration screening and claimed asylum in Canada in 2018, despite there being public videos circulated of this alleged terrorist participating in ISIS propaganda videos in Iraq. I'm wondering if you can tell us about New Zealand's screening. Do you have an effective screening system that allows you to try to find cases like this and prevent them from getting visas to travel to New Zealand?
Yes, we do. We have a very good information sharing relationship with our Five Eyes partners, and we work quite closely with our national security agencies who will notify us of anyone who is on any watch lists or is a person of interest to them, and that we factor that into our visa decision making.
Is there anything specific that you think New Zealand does better than other Five Eyes partners?
Not specifically. I think the information sharing with our security agencies is, again, because of the enforcement community is small, is done on a relationship basis, and we're very quick and agile in terms of sharing information.
And I've only got a bit of time left, but I noticed in researching some of your commentary, you've talked about the exploitation of migrant communities by organized crime, scamming them, scamming these people, breaching their visa conditions. I'm wondering if you could talk about what are effective ways that New Zealand's protected vulnerable migrants from exploitation by organized crime.
So we have a couple of products that we visa products. So a person who is certified as a victim of human trafficking can be given a trafficking visa to remain here, to escape the situation and to give evidence and or not. But the primary purpose of that visa is the protection. of that person to allow them to access welfare services and the like. And for people who report exploitation by their employer, we have a very fast-track process to put them on what is called a migrant exploitation protection visa, which is an open work visa for 6 months, which allows them to move from the exploitative employer, find a new employer, and get their immigration pathway back on track. But the principal reason for that visa is for the person to escape the current exploitative situation, and then that also allows us to work with that person to gather information from them, to see if they want to be a witness or even just provide information that allows us to take action against that employer. And if we prosecute an employer for migrant exploitation or for some lesser charges, we can put them on a stand-down list from employing further migrants for 6 months.
Thank you, MP Lloyd. Monsieur le député Ramsey, à vous la parole pour 6 minutes.
Mr. Ramsey, over to you for 6 minutes.
Kiara, Mr. Watson.
Kiara, Mr. Watson.
You come today and take time for this. Are you in Wellington?
I am.
My favorite song is I Wish I Was in Wellington by the Muttonbirds. So they...
I think they're performing on the weekend, actually. And yeah.
Yeah, all right. I'd like to know, do you have a clear, do you maintain clear data to know about what's the number of illegal foreign national and what's the number of illegal or foreign national who have offended? Is that the sort of statistic that you maintain?
Yes, it is. So once a year, we produce what is called an estimate of people who are unlawfully in New Zealand, and it has to be an estimate because it's a snapshot in time, and that was about 21,000 people last year. And in terms of criminal offending, we have a very, very accurate database because every piece of information that's shared with us by the court system, the police, or the other criminal jurisdictions, we record it in our case management files, and they are actively recorded under our priority 1. So yes, we have a very good list of everything that is reported to us. And as I say, the reporting is not infallible, but it's about 99% reliable.
Okay. And is there a minimum sentencing where the offenders becomes eligible for being expelled?
So any temporary migrant who is sentenced to imprisonment will be made liable for deportation. Any resident who has sentenced to imprisonment, there is a kind of a scale by how long they've been here. So if a person has been here for 10 years and they're well settled and they are sentenced to a minor term of imprisonment, for example, they may not be deported. And in terms of the lower level offending, we do have some discretion for very, very minor offences like speeding tickets or things that are not against public order. We may on a special case review allow the person to remain, but it's on a case by case basis, and there's a little bit of discretion in there.
One of the things you alluded to was that people were being expelled as soon as their sentencing term, or they would go finish their term in prison. That would mean because I'm assuming you have due process before being expelled, that would mean that those procedures would take place during the time the person is in jail. Because that is something interesting that we may be able to learn from you.
Yes. So the process as it happens is a person will be. I'll use an example of 12 months because it's easy to work it out. So a person will be sentenced to 12 months imprisonment. They'll be eligible for parole at probably 7 months. So we would engage with them within a month of them being sent into prison. We would serve them all their paperwork that would allow them to to the due process of appeals, which can take up to 42 days. So by the time they are able to be released, everything is ready. The flight is booked. The escorts are prepared. We literally pick them up from the prison gates and take them to the airport.
Now, about the people who abscond, I've spent enough time in New Zealand to know that even though it's a small country, you can get lost easily, especially in South Island. How do you go about to find those people?
So we would use what I would call just basic modern investigation techniques. We start with their last place of with all of the other agencies in the community who will share information with us. So we have a single police force in New Zealand. We can have access to other government departments' records if we request them properly. So things like our social development agency and a number of other government agencies. And we also have a what's called a crime line or a Dobbin line where we receive information, anonymous information, and we also, in some cases, in the more serious cases, we do operate human source intelligence, so informants, and all of that information is processed through our intelligence system and gives us kind of refines where we can look and find people.
I would just point out to it that the recent bill C-12 that is in Senate right now will allow us that communication that Mr. Watson is between agencies, which we had in Canada, but now we should be on par with New Zealand. So
good to hear.
And hopefully we'll beat New Zealand in rugby sometime in the next 10 years. 10 years.
Mm-hmm. Maybe even before then, but we'll see. Mais avant ça, Madame de Bellefeuille.
Please go ahead for 6 minutes, Ms. de Bellefeuille. Thank you very much, Mr. Chair. Thank you, Mr. Watson. I'm not sure if you're receiving interpretation. Can you hear?
Parfait, merci.
Perfect, thank you. So, I'm a Quebecer, and when you're a Quebecer, you always try to find a family connection with people who we meet. So I can tell you that my grandson, he has a lot of family in New Zealand. He's currently living in Australia with his parents, and the family told us that they love New Zealand, and it's really at the top of my list to go and visit and to see some of that family of mine living in New Zealand. So we received the document that you submitted, and we saw that you had changed the number of foreign nationals that you expel over the years. So would you be able to share more details with us on your best practices? What made you capable of expelling more people last year, for example?
It's a good question, and I am... prior to COVID, we were deporting quite a few people, and obviously when COVID came, the ability to deport people was compromised, and so we are just now returning to post-COVID levels. But in terms of how we achieved those additional numbers, we took a more of a case management approach to our lower priority deportations. Our priority deportations, criminals, are always there, and they're picking them up from prison is actually quite an easy thing to do. It's very straightforward. But with the people who are in the community, and when we've spent a lot of time actively working with them so that they go home under their own steam. So the main increase was in what we would call voluntary departures or self deportations, where our approach is to we would visit these people weekly and kind of convince them of the that it's the wrong thing to do to stay in New Zealand and convince them to return home. Unfortunately, we're not allowed to offer them any incentive to do that, but we can disincentivize them from remaining because if they're on our radar, they can't work. They can't even work illegally because we will be keeping an eye on them. And so sometimes there's two things that work in that space. One is that you allow people who are not criminals or who are not serious criminals, you allow them the ability to control their own destiny, and sometimes that is an empowering thing for people, and they will realise the error of their ways and just simply go home. And it also means that it's a cost saving for the government, because sometimes their family, and often they'll have offshore remittances once they've made up their mind to return home. And the third incentive that we can offer them is if they do return home voluntarily without being deported or through a cooperative action, after a period of time, they can then have the opportunity to return to New Zealand, and that's never off the table. So it's a case management approach for our less serious overstayers.
Microphone, please.
Okay. Excusez-moi.
I beg your pardon. Mr. Watson, after leaving prison, you were telling us that they are accompanied to the airport so that you can make sure that these individuals do leave your country. I imagine that in New Zealand, just like in Canada, there must be countries for you where when you send these individuals off, there are treaties that you have signed that allow you to send that person back when the political situation is unstable. So what do you do when someone has a removal order and has completed their sentence, but you're not able to send them back to their country because you have signed international treaties and the political situation does not allow it?
So we monitor the case until their prison release, and we ask our corrections colleagues to work through the parole system so that when they're eligible for parole, we can engage with them again long before they're released. We would know that we're not able to remove them. We don't hold them in detention. What we do is we would, if they're still liable for deportation, we would manage them in the community through a residence and reporting agreement, which is a lawful document that says you must reside at this address and you must report to our officers at a period of time. For matters where it's a serious national security threat or they are a serious threat to the community, we may detain them, but we have in recent times, based on sort of United Nations advice and human rights advice, where possible, we will allow people to remain in the community, particularly if there is no prospect of deportation, because essentially they are being held in a corrections facility. We don't have immigration detention, so they are being held in jail with no prospect of release or no prospect of deportation. And we have had there's been overseas court decisions, and the United Nations frowns very heavily on that. And I think it's the right decision. I think, we have to treat people in a fair and humane way.
Merci.
Merci beaucoup, Madame de Bellefeuille.
Thank you very much, Ms. de Bellefeuille. Ms. Kirkland, for 5 minutes, please.
Thank you very much. I appreciate this conversation. We can always learn things from each other, and it's always a great opportunity for us to learn from you, and hopefully we can reciprocate down the road, Mr. Watson. So as per Canada Border Service Agency removals program, persons subject to removal have to pay their own return travel. Of course, if the person is unable to pay, right, as that will happen often, Canada Border Services Agency will do so on their behalf. We'll attempt to recover the cost if the person seeks to return to Canada, and in that way. In New Zealand, who bears the cost of removals?
We have a similar process. So as I alluded to before, where people can pay their own removal costs. We would encourage that, and because it gives them an opportunity to return, and it's the right thing to do. So, but where people simply cannot pay, and we need to remove them, the state pays, and I have a budget for that, which needs to be carefully managed because it's a public appropriation. But there is an expectation, like as you said, Ms. Kirkland, that if the person wishes to return, or they have to repay that debt in full.
So how often do you have any comments on how often that your government is able to recover those costs? Any idea there?
It's very difficult because the person's offshore and we have no jurisdiction, it's extremely unlikely that we recover costs. I think it's probably under 10% of cases. Okay, it's very difficult.
Yes, indeed. So when an individual refuses to cooperate with immigration authorities, they go no contact. You start to wonder where they are. I wonder if you could comment again. I know you touched on it, but if you could comment on some of the enforcement tools that New Zealand uses to locate and remove them. I think you mentioned you're using some digital tools as well. So if you could elaborate, that would be great.
Yes, so we obviously have good information sharing with people, and we have in terms of digital tools, we're using AI a little bit to triage and kind of suck information out for us prior to identify where people are. But the main way that we find people who have gone underground or are difficult to locate is through some good old-fashioned kind of investigative work, really, asking questions, a little bit of surveillance, understanding where, just following the trail a little bit, and then one of the things that we've changed to do is we try and understand where the person's working. Because it's much easier for us to pick someone up at work, and it also allows us then to have evidence to prosecute the offending employer. In terms of the digital tools, really we don't have anything special. We just have a case management tool that allows us to keep information and record information, and we do have data matching with some other agencies that allows us to sort of see where a person who is wanted may have touch points with other government agencies, and we do have a lot of liaison with the sort of the groups that represent the diasporas in New Zealand, because it's our experience that the various kind of groups that represent the ethnic diasporas in New Zealand are very anti people who don't stick to the rules, and more often than not they will kind of hand them over, or kind of, because they've done the right thing, and that they want that they feel that these people are doing a disservice to their kind of culture.
I appreciate the urgency that your government takes in making sure those who are incarcerated, I'm sure you have, bureaucratic slowdowns like every other country. How often, I'm curious, the goal obviously is to make sure they're ready to go from prison to airport. Are there a number of cases sometimes where timing just can't work out for that to happen? Or are you pretty successful?
We're pretty successful.
That's great.
Generally, when a person makes if a person makes an asylum claim in prison, we obviously can't remove them. So we just go through the prison release process and then monitor them in the community.
So the urgency, is that my time? Oh, that time goes by so quickly.
Yes,
Thank you,
it's
sir.
often like that. Thank you, and sorry, Madam Kirkland. MP Essasi, turning to you. MP Akan for 5 minutes, please.
Thank you very much, Mr. Chair. So, Mr. Watson, thank you very much for joining us today. In this committee, we heard President Brian Suwe of the National Police Federation, the union who represents members of the RCMP. And we discussed how our government is hiring 1,000 new officers in both our law enforcement agencies for CBSA and RCMP that are involved at the border. So I am coming from a technical background, and I did projects in the past for public safety and security. And I was curious as to what type of tools and technologies are used when identifying criminal admissibility and executive removals in New Zealand.
So you're talking about what type of IT systems we use?
IT or any other technical systems that can involve in CCTVs or anything that is used for removal processes that involves tech?
So we're not very high tech, to be fair. We have a case management system. We have facial recognition software at the border that has some ability to identify people who are not eligible for entry. We do the New Zealand Police have some kind of, they do have a closed circuit TV and security cameras around the streets, but we as yet and don't use those for identifying people who are unlawfully in New Zealand. It's not. I'm not sure we would be able to reach that threshold at this stage.
Okay, thank you very much. I understand the facial recognition is usually used at like airports and certain areas. Okay, thank you very much for that. So, as you know, in Canada, we have the Immigration and Refugee Protection Act, and similar to your Immigration Act, which both serve the purpose of regulation of the immigration. So today we tabled a new legislation for lawful access, which has a very strong support from all levels of law enforcement in Canada. And I know in Australia also has a very strong lawful access provision, giving law enforcement the tools to access the data relevant to assist in investigations. So from a legislative standpoint, are there any statutory mechanism that empower law enforcement to collect, share, and operationalize intelligence when addressing criminality in New Zealand?
Yes, we have some statutory provisions in our Immigration Act that we can request information under, but the main vehicle that we use for information sharing is in fact our Privacy Act. So there is a principle in our Privacy Act that says that for the purposes of law enforcement, you can share information, personal information, and it has to be requested in there's a form that it has to be requested. So basically what we do is if we want to request information from another agency, we give the person's name, the reason that we want it, so that they have breached the Immigration Act or they've committed whatever offence, and we request any holdings that they may have on that person that may assist us with that investigation. And that's quite successful.
Now I'm curious about the length of this process, because in Canada we do have to go and have a judicial permit to get to that access to the information. And it's a lengthy process. Even today, the police has mentioned that it can go up to 11 weeks in really serious cases. What is your experience when it comes to the length of those processes for this form and getting the approval?
It's much quicker than that. In really serious cases, we would escalate it, and we could get the information the same day. And the other thing that I was going to mention is we have, between some agencies like the police and us, we have these approved information sharing agreements, which mean that which gives them permission to proactively share with us. So, for example, a migrant is convicted of an offence, we will not need to ask the police about that. They will tell us, and that is done through a legal agreement vehicle called an approved information sharing agreement, which is a process under our Privacy Act. And for the transactional stuff, it just really depends on workload. But if we needed information quickly and it was a really serious offence, and public safety depended on it. I'm confident that I could get the information from the police or the other agencies, if not that day, the next day.
Sorry, MP Akan. We must now turn to MP de Bellefeuille for another 2 minutes and a half, please.
Merci beaucoup.
Thank you very much, Mr. Chair. Mr. Chair, I really find this wonderful that today we're able to exchange and have a discussion with someone on the other side of the world in New Zealand and talk about practical solutions. I would also like to congratulate our interpreters who make it such that you can understand me. Our interpreters are good today. I want to say hello to them. I also hear a man's voice, and that's a rare thing when we hear our interpreters' voices, so I wanted to congratulate them. Mr. Watson, you have answered all of my questions. I found our discussion very interesting, and I don't have any questions for you, so I'm now going to let the chair manage our time, but I would like to thank you once more for being with us and for your great generosity, because I know you are not at all in the same time zone as we are. So thank you once again on behalf of the committee for being here with us as a witness.
Madame de Bellefeuille.
Thank you, Ms. de Bellefeuille, for your usual kind words and also for being so kind to our witness. And now we have Mr. Au for 5 minutes, please.
Yeah, once again, thank you for participating in the hearing. And I have a few questions, and I would just go right into the questions. Now, the first question is I want to get some clarifications, because when I read the background information, it seems to me that in New Zealand, a person can be deported if there's a certain time of imprisonment, even if the judge's sentence is less than the sentencing that's required.
Yes, that is the case. I don't have it's quite a technical piece of work, and it's in our legislation. I don't have the actual specific details, but you are right. There is a sliding scale of imprisonment for residents visa holders. A person who is on a temporary visa, no matter what period of imprisonment they are sentenced to, if we deem them to be of bad character, we will deport them.
Right. So for example, right, in your case, saying that if the offense was committed within the first 5 years of obtaining residence, and the court has the power to impose a sentence of at least 2 years in prison, even if the actual sentence is less. So in other words,
yes, that's right. Yeah.
Yeah. So in other words, the court can sentence lesser than the what's permissible, but still the person can be deported.
Yes, that's right. The decision is made on the maximum available sentence for that offence, because I'm not sure in Canada, but in New Zealand it's very rare that a person receives 5 years for a 5 years imprisonment. There's always a starting point, and then there's mitigations, and judges make decisions. They have judicial independence. Yeah.
Yeah, I asked that question because in Canada we've seen cases in which the judge, cut down the sentence so much to avoid that the person has to be deported. So I find this to be very enlightening. My second question is, we all struggle between, the concern of public safety and human rights. So again, how do you strike a balance between public safety concerns and also the safeguarding human rights, especially in cases such as people who have already committed a crime, exhausted all legal applications to stay, and then finally claim for asylum or claim to be a refugee. So how do you avoid that kind of situation from happening in New Zealand?
So you use the word striking the balance. That is the exact name of our strategy. And in a case such as you have referred to, if it's a second or third and subsequent claim, obviously we are required to consider that claim, but we do have a fast-track process, and we work very closely with our refugee determinations team for those people who are third and fourth and subsequent claims. And if they are found to be unfounded, we will we prioritise those, and we work very quickly. Once the claim has been determined, we will then start to engage with the client and begin the removal process once all appeals have been exhausted. They are complex cases, and we've had a couple where we've had multiple claims, but we generally kind of get there in the end. It just takes time, and you've got to follow due process.
To my third question, now you seem to have a very effective and also a very tight timeline for processing those deportation cases. How successful you have been to follow the timeline? Is it that in most cases you are able to fit into the timeline that you specified in the process?
Yes, particularly for criminal offending, where people are in jail, we get early notification, and we prioritise those cases. So the work is done at the earliest possible opportunity, and then the case just sits ready to go. And again, as I said, when they're released from prison, they are picked up and put on a plane. And again, because we prioritise criminal offending, we are able to work through those cases quite quickly, and we put most people working on that. What that does mean, though, is a trade-off in terms of the kind of cohort of people who are just here unlawfully, don't commit any crimes. We tend to not have the time to deal with those, so we use other approaches with them, such as phone calls and text messaging, to try and just maintain some contact. But yes, we prioritise criminal offending because it's what the country expects us to do, and it's what the government is very, very clear that when you are a temporary visitor to New Zealand, or you have been allowed to reside here, that you obey the rules, and that there are consequences for not obeying the rules.
Okay. My final question is
I'm sorry, MP.
case management.
I would like to be more generous, but unfortunately we've exceeded the time. Leading to MP Assassi for 5 minutes, please.
Thank you, Mr. Chair. Thank you also to Mr. Watson for appearing before our committee. I found this very informative. I wanted to follow up on the question that MP Lloyd asked you. He asked you about the strengths of the procedures in New Zealand with respect to deportations and removals. I understand that through the Five Eyes, you have been privy to how our system works. What would you say the strength of the Canadian system is?
I have to confess, I'm not overly familiar with your system, but the little I do know, I think it's you have a similar approach to New Zealand in that it's a balanced approach, and you do have strong humanitarian considerations, and you do process people who are prioritise criminal offending, and your in my experience in dealing with the Canadians is that they always seek information and always very helpful. So I'm not really answering the question because I'm not really familiar, but
we can move on to the next question, if you will.
Yeah.
So in the event, for example, that amongst the Five Eyes, several have designated a group as a sponsor of terrorism or engaging in terrorist activity in their own jurisdictions, should they come to New Zealand requesting information, would that information that has been requested be forthcoming from your authorities on that particular basis?
Yes, I would say it would, because there are channels for pushing that information through, and we are a very active and cooperative member of the Five Eyes. Sorry, there was a background call coming in.
So you don't just look at whether a particular individual they're asking you information about actually engaged in criminal activity only in your jurisdiction. You would also accept to be forthcoming with information if that individual has engaged in criminal in what is deemed to be criminal activity in another jurisdiction as well.
Yes, that's correct. Yeah.
Okay. And then just to follow up on the question that my colleague MP Akan asked, she was asking about data sharing permission forms. How does that process work? I think she had a follow-up question for you, but she wasn't quite sure how the forms operate and who authorizes them.
So we've used our lawyers to design a template that meets the legal requirements, because we're requesting information using a piece of legislation. So we have made it as simple as possible. So we have across government, the forms are pretty standard, and we've depending on the seriousness or the nature of the information requested, we're quite permissive in terms of our frontline officers making the requests themselves, direct to the other agency. In a case that's a bit more complex, I would probably expect a one-up sign out or some legal advice. But it's a well-used, long established process that we use, and based on a lot of trust between government agencies. So, like we trust each other not to drop the ball and not to get this wrong, because we are dealing with other people's information, managing other agencies' information, and I'm sure, as in Canada, privacy breaches where sensitive information is got out into the public domain through public service incompetence is treated very seriously.
My questions, Mr. Watson.
Thank you, MP Sassi. MP Al, for 5 minutes, please.
Very good. Thank you very much. I'm glad that I have more time to ask questions. Now, I just want to ask a question about case management, because you mentioned that you use the case management approach. So in your case, which department is the primary gatekeeper for the case management to make sure that the ball is not being dropped? So is it the correctional department, the justice department, or the police?
So each of those agencies maintains their own systems with integrity to maintain the integrity of their data, and we have designed what we call, to enact the approved information sharing agreements, we have what we call APIs and business rules that allow the data to be shared mechanically, particularly in the proactive space, and where we share data by using the form or the manual request, the integrity of that is basically maintained by training, quality assurance checks on those requests to make sure that they are lawful and we're not just going fishing. And we have very good, we have an all-of-government agreement about the management of and sharing of information, which we are held accountable to by our Parliament.
The question I have is that so New Zealand's humanitarian appeal test requires exceptional circumstances or unjust or unduly harsh impacts. So how often the criminals were being able to use that kind of test to avoid being deported?
It doesn't happen very often. Occasionally, the higher courts will kind of overturn our decision, and it's generally based on a family reason, but we still are able to successfully deport criminals who have New Zealand-born children and New Zealand families, because that's the courts have upheld that thinking. And so, just having being married to a New Zealand partner or having New Zealand-born children doesn't, it's not of itself exceptional circumstances. Sometimes courts will make decisions, and that's what they do, and we can either appeal that or we can accept it.
Okay, and another question is that now your minister has the absolute discretion to cancel or suspend deportation liability. So again, how has it been your experience in allowing that to be the power of the minister? Has it been abused, or have people accused for inconsistency or giving the minister too much power?
So the minister delegates that to senior officials, and and to do the thinking and do the prep work. The minister regularly has what we call calibration meetings with her delegated decision makers. And she also has an associate minister who does a lot of this work for her, who also is part of those calibration meetings. But the key here is that the minister very rarely intervenes in cases. But if she does, she always gives good reasons for it. So I'm not aware, I don't believe there's any abuse of that process. It's a very thorough process, and it's managed by very senior officials such as myself and my colleagues. And it's just part of our legislation that we work with.
Thank you. Those are the questions I have.
Thank you, MP Al and MP Palowski, to end this portion of our meeting. 5 minutes, please.
Mr. Watson, I'm curious about your use of the term bad character and removal of people of bad character. I would have thought if you broadly interpreted the meaning of bad character, you'd include pretty well all the members of the Conservative Party on the other side. I don't think that's likely the basis of your interpretation. What you gave us some ideas of what constituted bad character. I'm hearing comments from the other side. What besides being a member of the Conservative Party, what are the other kind of criteria for constituting bad character in New Zealand?
So we start with criminal offending, and sort of stepping back from there, sort of breaches of the civil jurisdiction. So people, committing, say, tax evasion or something like that that's in a non-criminal, and it's quite broad. But generally, we would consider bad character to be criminal offending. You jest, but sometimes a alignment with some sort of ideology can be considered of bad character, and that's quite a difficult one to deal with. But it's generally criminal offending or how they conduct themselves in the community. If they conduct themselves in the community in a way that causes harm or offence to other people, that is not. There's not a lot of it in New Zealand because we are quite a open and understanding society, and we certainly tolerate a lot of different ideologies.
Okay. Now, I also understand part of your mandate is looking at exploitation of foreign workers. So I was interested in this. I understand New Zealand brings in about 5,000 workers from Vanuatu every year as temporary foreign workers to work in agriculture. I'm kind of interested in this. I lived 5 years in Vanuatu, and I understand there are some cases of exploitation. Moreover, my understanding is that the work permits the New Zealand government issues is for one specific business to be able to employ someone, and I think we in Canada do the same thing, and this opens the door for exploiting workers who may feel that if they complain, they're going to be sent home. And so what does your government do to kind of ensure that being tied to one single employer doesn't result in the exploitation of workers by unscrupulous employers?
So we have two schemes. The scheme that you're talking about is called the Recognised Seasonal Employer, and those employers have to jump through quite a number of hoops to be accredited. So they are audited on their pastoral care plans, their accommodation. They have to provide worker accommodation, and that has to be of a suitable standard. And they have to demonstrate to us that their internal processes are compliant in terms of things like minimum wage and wage deductions. And if they don't, and they are audited by us, if they don't, they lose the ability, or may lose the ability to hire migrant workers, which basically means they're dead in the water as a business. So there's a strong incentive to comply. And for the broader labour market, we have what's called an accredited employer scheme, which is quite similar. So employers have to demonstrate to us that they have all the checks and balances in place to prevent migrant exploitation. And so what that does is that allows us to investigate and more monitor and audit their processes on a risk-based cycle to ensure that they're behaving properly. The final thing it does, and I'm conscious of time, is that those who operate outside those schemes are deemed to be high risk by us. So that allows us to prioritise them and pay them a lot of attention because generally they're the ones who will be committing the exploitation.
Any time? No. Okay. Thank you, and thank you for appearing before us. I appreciate it.
Thank you.
And thank you for saying that, MP Polowski, which I will repeat again on behalf of all members of this committee. You heard our gratitude and our appreciation of the time and the input you put into this exercise. Despite the physical distance between you and us, we feel very warmly appreciative of your strong and warm contribution. So we wish you a great day. I know it's the beginning of your day, and we look forward perhaps to meet you in person at some point. So thank you again, and enjoy the rest of the day. Et pour les autres,
thank you. Thank you. In closing,
Sarah, please, yes, please, Mr. Watson.
Yeah, thank you. Just in closing, I noticed that a lot of the members still had further questions. I'm happy to take those questions through email, or if you want to, you have my email contact through your secretariat. Please forward them, and I'll get people who are a lot more deeper in the business and have a lot more knowledge than me to answer them for you, because I too value this interaction, and I do really happy to provide more information. So thank you.
So that's a generous offer, which we have heard really well, and we will be sharing your contact details for the use of MPs. Thank you again.
Thank you, sir.
Matewa.
Alors, pour les autres députés.
For other members, we will suspend for a few moments because we will now be moving into an in-camera meeting. In fact, we will adjourn this meeting and come back again, some of us anyway, for another meeting.
Forward to the next steps.